Barabari 3, which is that fatal decision.
Right.
Now, Justice Chandrachud tells us that he got some divine inspiration. Well, it was. It was. The sad tragedy is that it was Sangh Parivar and Modi inspiration. And we can't run away from that in the most important case of this century. Both the Prime Minister and Chandrachud are psychotic about publicity. But eventually, Modi maneuvered and outmaneuvered Chandrachud. Unfortunately, Chief Justice Chandrachud developed in the course of his later years a psychotic love for publicity. This psychotic love has sent a wrong message to all judges in India. Prime Minister took full advantage of it and has embarrassed the Chief Justice and has embarrassed the judiciary. I just hope that this never takes place ever again. And we have no idea as to how many High Court and Supreme Court judges have been appointed on the basis of the Sangh Parivar. This is, in Romila Thapar's word in another context, bullshit. Total, complete bullshit. Because the question to him really was, on which he volunteered himself, is that intuitive part of judicial decision making. The intuitive part away, and there is no judicial decision making.
Correct. That's true.
The intuitive part was the basis of Chandrachud's judgment in Barabari.
And then they celebrated it.
Of course, unfortunately, our Prime Minister is largely to blame for this iconization. He is a travel agency in foreign affairs for himself and for the country, because we are faced with a challenge in 2025, which we were never faced with before.
Which is that?
An elected dictatorship,
I see.
fueled by fundamentalism, arbitrariness, capriciousness, discrimination not just against people, but also against various opposition states. Justice Chandrachud, as he then was, asked me, what is your answer to the title? So title vested in the Muslims, and only a prescriptive title vested in the Hindus. That was the settled matter. Now, once you have destroyed a mosque, committed trespass into it, on what basis did the Supreme Court in 1994 give the right to belief and the right to pray in that masjid? This was J.S. Verma's, I think, signal failure, a failure that accelerated in Barabari 2, which we got then said should go to a larger bench,
right.
and then in Barabari 3, which is that fatal decision.
Right.
Now, Justice Chandrachud tells us that he got some divine inspiration. Well, it was. It was. The sad tragedy is that it was Sangh Parivar and Modi inspiration. And we can't run away from that in the most important case of this century.
And the fact of the matter is that he now explains in his various interactions with the press that what he meant was that, everybody believes in God, so God tells you, to walk the right path, and that's the divine inspiration that he was talking about.
This is, in Romila Thapar's word in another context, bullshit. Total, complete bullshit. Because the question to him really was, on which he volunteered himself, is that intuitive part of judicial decision making. And the intuitive part of judicial decision making is the most fundamental part, as people like you, in my time with you, have taught me. Take the intuitive part away, and there is no judicial decision making.
Correct. That's true.
The intuitive part was the basis of Chandrachud's judgment in Barabari.
And then they celebrated it.
Of course.
You
see, unfortunately,
how do you celebrate a judicial decision?
You don't. Because unfortunately, Chief Justice Chandrachud developed in the course of his later years a psychotic love for publicity. This psychotic love has sent a wrong message to all judges in India. Unfortunately, our Prime Minister is largely to blame for this iconization. He is a travel agency in foreign affairs for himself and for the country. Both the Prime Minister and Chandrachud are psychotic about publicity. But eventually, Modi maneuvered and outmaneuvered Chandrachud. Chandrachud claims that it was an innocent affair. If innocent, it's unheard of. But the Prime Minister took full advantage of it and has embarrassed the Chief Justice and has embarrassed the judiciary. I just hope that this never takes place ever again. All kinds of deals will have to be made in the post-Trump era. These deals are being made. But with him electioneering, and with him there at every juncture, on every public occasion, saying something or the other, I don't think he has the time for governance. He has only time for his own iconization.
But he says, the economy is doing fabulously. India is, in fact, going to become a Vishwaguru. By 2047, we'll be Viksit Bharat. These are all dreams that he is selling.
2047, abhi dur rast, in that famous phrase.
That's true.
I think this economy would have succeeded without the intervention of the state.
That is true. I also believe that. I've been saying that.
And the economy is progressing well. It has something to do with the people of India.
That's true.
To some extent, monopoly capitalism, and to some extent, capitalism. But the strength of the people of India, which is phenomenal, Kapil.
That's true.
They will go and work. They will create startups. They will be there from morn to night, 7 days a week. It is these people who have really accelerated our economy.
Okay, let's move on to something else, which is that you argued the Barabari Masjid case. I think for how many months?
3 months at least.
3 months at
But I argued it from 1974 onwards.
Correct. And ultimately you were landed with a decision that you've criticized publicly. What are your thoughts on that?
The Barabari Masjid was actually an easy case to decide. It was based on title to 1480 square yards.
Okay.
Nothing more, nothing less. It was a title suit. During the course of the argument, Justice Chandrachud, as he then was, asked me, what is your answer to the title suit? I said, why are you asking me? Ask them. He asked them, and they said, belief. And this is writ large across the Barabari judgment. See, in 1885...
So title was decided on the basis of belief?
I believe so. Because in 1885, a suit had been decided all the way to the Judicial Commissioner and beyond, that title vested in the Muslims, and only a prescriptive title vested in the Hindus. That was the settled matter. Prior to this, judges...
Not anymore, I think. The present
Sorry?
not anymore. I don't think the present Chief Justice is the present judiciary.
See, set aside the present Chief Justice. The message is that apart from lectures that you deliver or formal occasions, you should not open your mouth. Shekhar Yadav has. Victoria Gauri did.
Yes,
So the message that has gone on is you can indulge in publicity, you will not be condemned for it, and we have no idea as to how many High Court and Supreme Court judges have been appointed on the basis of the Sangh Parivar. We don't know, but it is dangerous.
Actually, we know. We know, because if you go to the websites of every High Court, and every High Court tells you, the judges themselves tell you that they belong to, they were government pleaders, this, that, and the other. And if you go into the history of those government pleaders, you will find that a lot of them were...
That by itself is not enough. You have been an additional Solicitor General. That has no bearing whatsoever on your future career at the bar.
No, that's true. That is true.
And therefore, the fact that they were pleaders just shows...
No, that their background is RSS.
No, the background is not completely known. Now, Chandrachud says that he gave a very positive, or rather negative, account of Shekhar Yadav. Why was he appointed?
That's true.
And therefore, we still have to look at the saffron past. Judges like Justice Muralidhar are not appointed. And the collegium system has been compromised in a very big way because of lack of transparency. And that's a huge problem, because the government covertly and overtly makes sure that judges that they don't like are not appointed, and judges they like are.
But that's the judiciary coming to the executive then.
Of course. And that
So
is
what's
why
the solution for that?
I think we have to review the appointment of judges. I was part of that decision where the NJAC was declared unconstitutional. This was at the instance of many people, including Fali Nariman. I think Chalameshwar may well have been right. We need a more transparent way of appointing judges. At least with a constitutional authority, we will have more information, more public participation, not this closed system.
No, I agree with you. The problem is if the government comes into the picture, and the government, this government has been winning elections one after the other. It's a very powerful executive today, perhaps more powerful than any other executive in the past. Even during the emergency, I don't think Indira Gandhi was as powerful as Modi is today. The reason is that this government has captured all institutions, from the media to the judiciary. I won't say the judiciary that'll be contempt of court, but he's certainly trying to influence them. Then institution of governors, vice chancellors of universities, the election commission, public service commission. There is no institution that is left.
There is a total capture. That is why in a recent lecture, I said governors have become the hitmen of the central government. It wasn't this case before.
That's what I mean. It's much worse today than it ever was.
Now they want to control everything. There is even an item in the newspaper that they're trying to take over the Habitat Center and the IIC.
No, the Habitat Center is, the IIC is the latest one. The Habitat Center is...
Habitat Center has more or less been dominated by the president, close to the BJP. There was a rumor, I am told, that this candidature has been withdrawn. Nipen Mishra, very close to Modi and in charge of making the temple, has withdrawn his nomination to the Board of Trustees. Gymkhana is in great difficulty.
They've taken over already.
Completely. And therefore, there is no institution left, but above all, the targeting of the media, of opposition. This is actually worse than preventive detention.
Absolutely. That's what I was trying to suggest when you said that, people still have, confidence in the judiciary. But in this scenario, given the recent judicial judgments that have been rendered by the court, things look extremely despairing as far as I'm concerned.
See, Kapil, in 1951, when the Preventive Detention Act was flourishing, the Supreme Court said you must include due process in it. To that extent, preventive detention was controlled.
Yes.
This is worse. This is a situation which is worse. But, I have hope in the Indian people. I still have hope in the judiciary. What the judiciary must realize, that it isn't just the big decisions where it upholds or goes against the government. It is little decisions as well. Bail, such an important matter. And the record of the Supreme Court too has been uneven.
That's true.
Take the latest decision on the Allahabadi matter.
Yes.
The fellow has been told, you can't pursue your own profession. You can't exercise free speech. Now this tail under that has come in bail orders, and we know that some judges of the Supreme Court simply don't grant bail. It is in these minute areas of civil liberties that the courts have to be much more careful.
But actually the situation is much worse at the level of the special judges and the level of the sessions judges. There nobody gets bail. How do you deal with that system?
Well, I don't think that the Supreme Court who was rebuffed by Shekhar Yadav, or the High Courts have independent disciplinary powers of any great value.
But the High Court has.
The High Court does, but it has, in my research on the Allahabad High Court, has exercised these powers very arbitrarily in the matter of postings, in the matter of promotions. Look, today we have a service jurisprudence, both in respect to judges as well as the bureaucracy, which is huge.
Right,
what does
that's
it
true.
show to us? A very disgruntled state of affairs in the people who govern us.
That's true. Now, let's move on to something else which you've commented upon publicly, namely the Prime Minister, when Chief Justice Chandrachud was still the Chief Justice during Ganpati, visiting him, and his explanation to that. And I think you made some comment on that. I'd like to tell you to tell, on 370 again, you saw the court did what it did. What are your comments on that?
See, we've got to understand that India has an asymmetrical system of federalism. In the 6th schedule, 4 states have constitutions within constitutions. Why should it surprise us that J&K has an asymmetrical constitution, given by a long process of deliberation, both in the Indian Constituent Assembly and the JK Assembly? What was tragic was the use of the powers under 370. The 7th Amendment of the Constitution says 100 odd articles of the Indian Constitution will not apply to JK.
That's true.
This could only have been removed by the constitutional amendment process. By what process of amending power does Article 370 in an executive decision overrule constitutional amendments?
Absolutely, I entirely agree with you.
And the process on the 4th and 5th and later on in August was horrendous. Parliamentary majorities overrode the entire process of 370. Now, Article 3, by which you reorganize states, change their status, requires that you should consult the legislature.
That's right.
But as you pointed out, there were no legislatures.
That's right.
So what happened? Parliament then said, we are the legislatures, we'll consult ourselves.
Yeah, but the issue is that the court did not accept anything that the government said. You see, the court interprets Article 370 in a manner that neither the government interpreted it in that fashion, nor did the petitioners.
That may not be entirely correct, Kapil. They referred to a speech that the government had placed before them by the Sadr Riyasat in 1948, which became an important part of the judgment. Actually, that particular speech or concession made by the Sadr Riyasat was totally irrelevant, but became a part of the building block of the decision.
No, but that's not what the government argued before the court. See, the government's position was that we have the power to amend these provisions. The court said, your interpretation we don't accept. But if you read 370, the president could have amended or abolished 370 at the time when it was put into the Constitution, after the Constitution came into being. That's what the court ultimately said.
We may be at variance on our interpretation of that particular judgment. The court had to say that it wasn't following the line of the government.
That's correct.
But in actual fact, it did.
No, but not by upholding what they had argued.
To some extent, they accepted the argument, as I said, in this instance of 1948. And they also accepted the more or less ridiculous submission made by government that we will restore statehood. So they went along with the government.
That I never understood, because if Article 3 said, and we said that, look, forget about statehood for a moment. You reduce the status of a state from a state to a union territory, right? We argued that, look, you have to decide that issue, because there is no such example in the past of this having been done. And if you give this power to the center, they can reduce any state to a union territory, right? They chose not to decide that matter.
They didn't fully decide the issue of Article 3 and 4, by which the status was changed. You are right in saying it was unprecedented.
Unprecedented.
You've seen union territories becoming states, but you've never seen a state being dissolved into a union territory.
That's correct. And they said, okay, they will be given statehood because the Solicitor General has come and given a statement. What's the relevance of a statement of a law officer in a matter of constitutional importance?
This is both the government and the court subterfuge, making empty promises, fully knowing that it has to go through the constitutional process.
Okay.
The Supreme Court has become 34 judges, unwieldy, takes on too many issues, but still, oddly enough, has the respect of the people, which it lost during the emergency, which came back in a big way due to public interest litigation, lawyers like yourself. But it is in danger of losing this respect if it overarches itself and cannot stand up to the executive and parliament.
But tell me, I think, I just want your opinion on this. Ever since 2014, the polity is being challenged by the government in power, by the government actually taking control over all institutions in this country, which did not happen during the emergency. So in a sense, the danger to the polity today is much greater than it was in the emergency, and therefore the court needs to be a little more proactive than it was at that point in time.
I think that is correct, because we are faced with a challenge in 2025, which we were never faced with before.
Which is that?
An elected dictatorship,
I see.
fueled by fundamentalism, arbitrariness, capriciousness, discrimination not just against people, but also against various opposition states. Now this goes to the root of what I call the checks and balances of the Constitution. No constitution can survive if checks and balances are eroded. There is the democratic text of the Constitution. The checks and balances are the executive to parliament to the people. Election commissions, part of the democratic text of the Constitution. And I believe that these are being eroded. In Nehru's time, this was not the case. He made some disastrous decisions, the imposition of President's rule in 1959. But this did not deter an actual full debate in Parliament. When Nehru made a statement outside Parliament on the 7th Fleet, Parliament told him that, look, you shouldn't have done that. You have to make it on the floor of the House. He apologized. There was a contempt case against him in Madras. He entered appearance and succeeded. So checks and balances were always in place, even to a limited extent, though not so completely during the emergency, even in Mrs. Gandhi's time. She was humbled by Indian democracy,
That's true.
which is not the case here.
But